Major breaking news out of the United States Supreme Court, and it's not great news. The United States Supreme Court has denied cert in two Second Amendment related cases. Specifically, they denied cert in the Bianchi versus Brown case, which is the quote-unquote assault weapon ban case out of Maryland. They denied that. We'll talk about why I think they denied that. And they also actually refused to lift a stay of a favorable ruling in support of the Second Amendment in a case called Scour out of New York. We're going to talk about both these cases and what it means and what are the next steps for all of this and what is the Supreme Court thinking. All this we're going to cover in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so I'm not bringing you great news today. I'm not saying I'm bringing you catastrophic news today, but I'm bringing you somewhere between not great news and bad news. Specifically this morning, the U.S. Supreme Court issued their orders list, and there are two orders on there that specifically deal with Second Amendment related cases. The most prominent one is the Bianchi versus Brown case, which we've talked about considerably, which is the case that challenged the Maryland assault weapon ban, and which was on appeal to the United States Court of Appeals to the Fourth Circuit. The Fourth Circuit, which is an absolutely 100% anti-gun, in my view, anti-American court, came out with a bunch of games and just heard argument in the Bianchi case. There was a cert sought despite the fact that the Fourth Circuit was still hearing this case, and today the Supreme Court denied cert. But it's pretty clear why they denied cert in this case, because they wrote their order denying cert differently than they wrote it in the other cases that they denied cert on this morning, meaning the other cases not related to the Second Amendment. The court wrote, the petition for a writ of certiorari before judgment is denied. This is particularly important because the Supreme Court, in denying judgment, or denying cert, I should say, specifically uses the words before judgment, which is a clear indication that the thing that bothered them the most about the Bianchi case, and this is not a shock, was that the case was not final in the sense that the Court of Appeals had not weighed in and issued an opinion on this. So I think that's quite significant, that what bothered them about the Bianchi case, and again, this is not a shock. We all knew this was a bit of a Hail Mary, but there was hope because of the way the Fourth Circuit misbehaved. But the fact the Supreme Court made it clear before judgment they did not want to grant cert, and I think that's also a signal for other litigators, and this is sometimes, of course, the Second Amendment is part of a gestalt of American law. This is probably also a signal to all American litigators that fight cases before the U.S. Supreme Court, that the Supreme Court is generally not interested in hearing any case, not just Second Amendment cases, but any case before a final judgment or any interlocutory style case. They clearly are trying to discourage this, and that language that they added to before judgment, I think, is a signal. Now, what's interesting news, though, is that the Illinois cases, which in some ways are better cases for the Supreme Court to hear than the Maryland case, because the Illinois cases arise out of a more recent iteration of how the anti-gunners are trying to take our guns away in America. Because the Illinois cases of Bevis, Harrell, Naperville, so on and so on, they all involve challenges to the most modern style gun ban law that the anti-gunners have concocted in their brains. Whereas the Bianchi assault weapon ban was a challenge to a law that is much, much an older style. And I think the big difference is, as I recall, the Maryland law says that you can't have a semi-automatic rifle with two or more of these particular features, something along those lines. But the Illinois case is essentially you can't have a semi-automatic rifle with one or more features. In other words, it's a broader ban in Illinois and a more modern one. So I could see the Supreme Court wanting to take that one on as a general matter over the Maryland ban, which is like an older style gun ban case or gun ban law. So what's going to happen next? The Supreme Court has not denied cert or acted on the Illinois cases. They have not acted, and this is quite interesting. They denied cert in Bianchi using the language before judgment, but they did not issue an order in any respect in the Illinois cases. Now, what does that mean? Well, it means that the case will likely be reconferenced, relisted, and further considered. So here's the things that this could mean. Now, we don't know what's going on in the Supreme Court. Only the justices know. But here is what conceivably is happening. Number one, the Supreme Court is still considering whether or not to grant cert in the Harold Bevis cases out of Illinois, that whole gestalt of cases. That would be good news if they grant cert. I think that's not super likely, but it's not impossible, right? So the reason why I would argue that the Supreme Court might be more interested and more inclined to grant cert in the Illinois cases instead of the Bianchi, Maryland case is because the Seventh Circuit Court of Appeals, Diane Wood and Judge Easterbrook, in a 2-1 decision, wrote an extremely long and clearly wrong and clearly fallacious in all respects when it comes to applying the Constitution and the Second Amendment decision in those Illinois cases. So you could argue from the Supreme Court's perspective that the Illinois cases are better postured to hear because the Seventh Circuit Court of Appeals, granted it was in the context of an interlocutory appeal on a preliminary injunction, but still they wrote a 50, 60, 70-page opinion misinterpreting the Second Amendment and misapplying the Supreme Court precedent of Heller and Bruin and whatnot in the context of gun ban cases. So in certain respects, and Bianchi, the Fourth Circuit has not issued their decision about how to deal with gun ban cases post-Bruin. So in certain respects, the Illinois cases are a better set of cases for the Supreme Court to grant cert on than Bianchi. So it's possible they're still considering granting cert in the Illinois cases. Now, the other possibility, and if I had to bet $1 million, this is probably how I would bet, even though I don't want this to be the case. If I had to bet $1 million as to what's going on here, this is my bet. This is my best prediction. And it's not one I want to come true, by the way. But, on this channel, I'm just not here to talk about rainbows and unicorns. I try to tell you what the reality is on the ground, okay? The good and the bad and the ugly. So here's the good and the bad and the ugly. I think what is likely happening here is that the Supreme Court is going to deny cert in the Illinois cases on the grounds that these are interlocutory in nature, the cases are still pending, there's no final judgment, and yada, yada, yada. However, the reason why they're waiting to deny cert in the Illinois cases, but they denied cert in Bianchi already, is because one or more Supreme Court justices intends to write a dissent from the denial of cert, making comments or observations about the Court of Appeals decision there in the Seventh Circuit in Chicago. So I think if I had to bet $1 million, the way I would bet here is that the Supreme Court's going to deny cert in the Illinois cases, and then one or more justices will write a dissent criticizing, politely so, the decision of the Seventh Circuit, and they're going to say something along the following lines. They're going to say that we're denying cert in the Illinois cases because they're not final. There's no final judgment in this case. It's on a preliminary injunction, and we like a full record. But going forward, we want to offer some observations to the lower courts about this case, and then offer guidance about how they see that case. That is what I think may be happening here, which is why they denied cert in Bianchi today, because no one wanted to write a dissent in the Bianchi case, and they agreed upon that before judgment language to make it clear the reason why they're denying cert in Bianchi is because the Fourth Circuit was still here and the argument hadn't issued a decision, and thus they used the words before judgment. But then the Illinois cases, I think they're going to handle slightly differently by saying we're not going to get involved because it's on a preliminary injunction basis, but we are going to make some observations about that big decision to guide the lower courts going forward as they move their way toward a final judgment dealing with those Illinois assault weapon cases. Okay, so that is the bottom line here. I'm not happy about this, but I do understand logically why the Supreme Court may be doing this. It doesn't make me happy. If I were on the Supreme Court, I would probably be doing things differently, but I'm not on the Supreme Court, so it doesn't matter what I would do because I don't count when it comes to what the court actually does. Now, there is another important Second Amendment case. it's important, but procedure, again, it's another one of these things where I'm not super surprised the decision was the decision. And that is the case of Schroer. I'm going to mispronounce this, but Schroer is Srour. So I hope I get this right. But Schroer versus New York City. This dealt with whether or not the language in the New York City provision for getting a concealed carry permit of good moral character is constitutional. Good moral character is almost certainly unconstitutional under an objective standard, because you're likely asking, you're arguably asking potentially government officials for discretion in deciding what is good moral character. It depends on how they apply it. The federal district court in the Southern District of New York originally ruled in favor of the Second Amendment, saying that the good moral character requirement was unconstitutional under the Bruin standard because it gave rise to government discretion in who got licenses and who did not, which violates clearly the Bruin case. Then it went up to the Second Circuit Court of Appeals in New York City, and they stayed, which meant they put on hold that favorable Second Amendment decision by the Southern District of New York. And then it went up to the Supreme Court seeking a vacation of that stay. Justice Sotomayor denied the vacation of the stay. It was referred to Clarence Thomas. Clarence Thomas referred the question of stay to the whole Supreme Court, and the Supreme Court denied the request to vacate the stay. That, I think, is really a housekeeping issue. They just don't want to get involved in the minutia of some of these litigations just yet. So, yes, all of this, I would say, is a bad news day for the Second Amendment, but the game is still getting played. We'll see what happens. There's a lot of things that can go on with the Second Amendment over the next few months. It could be very favorable to us out of the U.S. Supreme Court, but no, I'm not happy they denied cert to Bianchi. I thought that was our best chance to get an assault weapon case up there for the 2024-2025 term. I thought the Illinois cases were a bit more of a long shot. The other thing is another reason why I also think that the Illinois cases are not going to be granted cert, because if I were on the Supreme Court and I were going to grant cert to the Illinois cases, what I would have done is granted cert to the Illinois cases, and I would have put Bianchi on hold and not denied cert in that case, right? If you think about it, if you're going to hear the cases out of Illinois, that is necessarily going to implicate the Bianchi case. So just hold the Bianchi case there at the Supreme Court, decide the Illinois assault weapon cases in 2024, 2025. That decision would be binding on Bianchi, and then you would GVR, meaning you grant cert, vacate the lower court decision, which technically there isn't really one, I guess, and remand it back to the Fourth Circuit to issue a ruling in Bianchi based on what you decide in Illinois. So I think that's another indication that it's unlikely we're going to get a cert grant in the Illinois cases. And I think it's more likely that what's happening here is they're going to deny cert in Illinois, and some justices are going to write a dissent from the denial of cert, providing guidance. But, we'll see more. We'll know more in the next few weeks. Maybe we'll be pleasantly surprised, and a week from now we'll be talking about how cert was granted in the Illinois cases. I hope and pray that happens, but I'm not optimistic, even though that's what I want to happen. All right, folks, hope you learned a little bit something here today. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe and resubscribe here, and we'll talk a lot more about the Second Amendment in the future here at the 4Boxes Diner.
Orders up. Table 2A.